Good morning, everybody. I'm David Sterling, Chair of the Chief Executives Forum, and just like to welcome you all to this session on You've Got the Power, the use of legal powers for good decision making in public bodies. I'll shortly be handing over to Claire Archbold, who is Deputy Departmental Solicitor and Honorary Professor of Practice in Public Law at Queen's University, to take us through this session. But just by way of introduction, just to note that we will be recording this. So just so that you're aware of that. The session will probably be about an hour and a half in total, I think, Anne, isn't that right? So just, I suppose, to introduce this topic, I was reminded that way back in 1998, Tony Benn, the veteran Labour politician, in a debate in Westminster, shared what he regarded as his 5 tests for powerful people. And he said, if one meets a powerful person like Rupert Murdoch, perhaps, or Joe Stalin or Hitler, or a grade 7 in the Northern Ireland Civil Service, you should ask them 5 questions. And I've always thought these were 5 really good questions. And the first one is, what power do you have? The second is, where did you get it? The third is, in whose interests are you exercising the power? The fourth is, to whom are you accountable? And the fifth is, how can we get rid of you? So, you know, I think they are a good set of tests that every civil servant or public servant, in a sense, should be able to answer. And they are relevant because I can remember many times during my career doing things, and I suddenly said to myself, actually, where does the power, where do I get the power to actually do this particular thing? So I wish this had been available at a much earlier stage in my career, but I do look forward to Claire taking us through this really important talk. And without further ado, I will hand over to Claire.
Thank you very much indeed, David. I'm just going to see if I can share my screen as now, hold on, I shouldn't have done that because now I can't share my screen. Hold on. I was absolutely delighted to hear that. Can you see my screen or?
Not yet.
Not yet, good. So I need to hit share screen first, and then I choose the screen that we're going to share, and I hit share. You would think that we had nearly practiced this, and then we hit slideshow from the beginning, and up it comes. Can everybody see that now?
Great.
Brilliant. So I am so going to steal those Tony Benn's 5 tests, because that's exactly what I want to think about today. When I was growing up on a small farm outside Belfast, which was during the Troubles and during direct rule, I thought that decisions were something and power was something that was exercised somewhere else, and that government was something that was done to us and not by us. And that's why when devolution came along, I joined the civil service, because it was an opportunity to help make a difference for the people of Northern Ireland. And everyone here is exercising power. It may not feel like it from day to day, but we are exercising power. Ordinary people, and us in the rest of our lives, have legal powers. That's not what we're going to talk about today. We're going to look at the specific powers of public bodies. We're going to look at the constraints on them, at the extent of them, and at how you can exercise them safely and in the public good. Now, this is the first time we've run this course, so I'd also like to ask you for your help today. Let us know what was useful, what was too simple, what was too tedious, what wasn't relevant, so that we can hone this course, and if you think it's worth it, make it part of the CEF offer. But let's go back and look at powers. What legal powers do we have in our everyday lives? I call it the power to go into a shop and buy a packet of Polo Mints. But anything that you do, you buy and sell property, you give a gift, you have a legal power to give that thing away. You enter into contracts. those of you who at the moment are fortunate enough to be able to find a cleaner or a gardener will employ staff. We can set up trusts. We can sue and be sued in court. We can make a will, enter a marriage or a civil partnership. We can, and those powers, we have powers and we have duties. For example, the duty to obey the speeding law. And those powers and duties may come from statutes, or they may come from the common law, from judge-made law. Now, I know that there are people in the audience who could buy and sell me and who have immense knowledge of the subject we're going to talk about. But bear with us a little bit while we look at what makes a public body different from any other legal person. Now, here we have a picture of Louis XIV, the Sun King, the most absolute monarch in Europe, who's credited with the phrase, "L'état, c'est moi," I'm the state. A public body is different from any other legal person, without getting too Louis XIV about it, because we exercise the power of the state. We can require people to do things they may not want to do, like, for example, pay taxes. We can stop people from doing things that they want to, like, for example, at the moment, going to red list countries without quarantining. And we can also allocate scarce resources between citizens. And that's something which has been very much part of our experience of the pandemic. There's not just the high street voucher scheme, but there's the question of who gets the vaccines first, of who gets access to business or furlough grants. And those are all things that we allocate between people. Now, there's a question of what standards should apply to us. The obvious answer to that is the Nolan Principles. I love this joke so much I had to steal it. The Nolan Sisters Principles of dancing, romancing, and chancing. You need to be a certain age to get that joke, I think. There's also the Nolan Principle of not wanting this man to make this face at you in an interview. But the actual Nolan Principles, the 7 principles of public life, they apply to us as civil servants. They apply to those of us who are public servants. They apply to our ministers and to our boards. Selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. And in tiny writing, which you probably can't read, I've put up an extract from the Pledge of Office. The reason that I've put it up is just to think about the ethical standards that should govern us when we're exercising state power. And you'll see at paragraph brackets C, D, close brackets down near the bottom of the page, it says to uphold the rule of law based on the fundamental principles of fairness, impartiality, and democratic accountability. That also comes into the Civil Service Code of Ethics. Obeying law and upholding the rule of law is set out in the Code of Ethics as part of our fundamental value of integrity. So what we do and how we do it is imbued with this sense of being bounded by law as a matter of ethics. And I think when I was working a couple of years ago on the Tackling Paramilitarism program, and we held, I think some of you were maybe in the room for the day that we held with our internal stakeholders to talk about this idea of a culture of lawfulness. And I think more widely than how we exercise power, there's a question about how we build a culture of lawfulness. You could say respect for the rule of law, but it's more than that. It's a culture of expecting that the law is our law and that it works for us and that we uphold it as ordinary people. So I thought that you might like to get into groups for a few minutes and just think about some people who are running up against some difficulties here. So we've got Mrs. Doyle, who's living downstairs from a party house. We've got Ted, whose landlord is hounding him for rent, and Dougal, whose milk float is in trouble because one of his biggest customers hasn't paid him for 3 months. So they might have two reactions. In a community that respects the rule of law, they might do one thing. In a community which has no culture of lawfulness, they might do something else. Do you want to have a chat about them in small groups just for 5 minutes? And then we'll come back together and maybe you can give me a little bit of feedback quickly. Anne, who's going to press the button?
I'm going to put you all in your breakout rooms now, and we'll bring you back in 5 minutes.
Brilliant. Thank you. Is everybody back? Brilliant. Would anybody like to give me some feedback about what did you think that Mrs. Doyle could do? What might she do in a community that didn't respect the rule of law? And what might she do in the lovely, nice community of the sort that we're trying to build? Anybody want to?
Well, and if she wasn't a law-abiding citizen, she could take the law into her own hands and send the heavies round. And sort her
Absolutely.
neighbours out.
Yeah. And what happens if she was a law-abiding citizen?
Well, there's several routes she could go down. So in terms of noise, she could go to the council and ask them to investigate. And if she suspected that there was drug selling or drug trafficking going on, she should probably report that to the police.
Exactly. And in a rule of law society, she could expect that the police and the council would take her seriously, and that they would be able to do something about it and to help her. And the contrast is, if she sends the heavies round, the people upstairs are going to be afraid. She's maybe going to be afraid that they'll come back at her. And the outcomes, you would hope, are very different. What about Ted? In a society that didn't respect the rule of law, what might happen to Ted, or what might Ted do?
It might get a rap on his door telling him he needs to be out of the place very promptly.
Exactly. And how might he go about getting his rent in a society that did respect the rule of law? I think we'd some people from the housing executive here, do we? He might apply for housing benefit. He might be entitled to it. What about Dougal? In a society that didn't respect the rule of law, what might he do? You're also law-abiding, you don't know. Anybody think of a sentence with the word Wendy's in it? He might put their Wendy's in a community that does respect the rule of law. What's his alternative?
Small claims court or something.
Yeah, absolutely. Take them to the small claims court. And the thing is, in a society that respects the rule of law, you expect, first of all, 1, that you'll go to court, 2, that the court will adjudicate the case fairly, and 3, that the person who the adjudication is against will acknowledge that they do owe you the money. So it's just really, it's a very simple, straightforward exercise, also to give you a chance to talk and to get to know each other, but just to think about, for me, the rule of law, it's not just about law and order. It's not just about finger wagging and, oh, you must obey the rules. There's a picture on the left here of one of the lively nights that we had during the summer, when people took the law into their own hands, and we had rioting and we had buses burned. And that, on an earlier occasion during the flag protests, there was more of that sort of thing. But one of those days, I had been in court that night, about midnight, dealing with some with a criminal matter. And the next morning, I was in St. George's Market, and it was just such a contrast, because it's not just that you expect that the law will deal with misbehaviour, but in order to for the stall holders to know that what they are selling is safe, that health and safety is being applied, that if you buy something from a stall holder, that your money is good tender, they have certainty in the contracts that they're entering into. You are having actually a really nice day out, buying nice things and making your weekend a generally more enjoyable place. One of the things that I think about kind of, well, what gets you up out of bed in the morning? What do we all do? Is we're making Northern Ireland a place where people can thrive. And for me, the rule of law is absolutely essential to that endeavour, which is why when we think about the powers of public bodies, because we exercise the power of the state, we can only make the moves that the rules of the game allow. And the rest of this session is about what the rules of that game are. So you will all know the next bit and you'll be able to sing along. Where does the power of public bodies come from? It comes from ultimately the Westminster Parliament, or more particularly, the laws which are made as acts of Parliament by the Queen in Parliament, that hybrid of the House of Commons, the House of Lords, and royal assent, which makes the laws that we all must follow.
Claire,
It's
can
called.
I ask you to put the slides back up?
Oh, have I not put the slides back up? Oh no, the horror. I thought they would have gone back up automatically. Right, you didn't see, let me end the slideshow. We're learning how to do Zoom here. Because we haven't, let me share my screen. This is the screen I'm going to share. I share it. And then I hit slideshow. And we whiz through. I can see this is going to get a little tedious because we've got more group exercises, but it'll be good revision. Here we are. Enjoy this slide. This is the difference between a situation where the rule of law is under threat and a situation in St. George's Market where everybody is enjoying the certainty of life that the rule of law brings. And so we get to the fact that we can only make the moves that the rules of the game allow as public bodies. Those rules are mostly in statutes that are made, now not just made by the Westminster Parliament, it may have delegated its authority to the Assembly, but ultimate legislative sovereignty rests with the Queen in Parliament. The doctrine of parliamentary sovereignty expounded by that great legal scholar A.V. Dicey. Here is a picture of A.V. Dicey and his great principle that the principle of parliamentary sovereignty means neither more nor less than this, that Parliament can make and unmake any law whatever, and no other person or body can override or set aside the legislation of Parliament. Remember the bits of the state, the legislature, which makes laws, which implement government policy and scrutinises the work of the executive. The executive, which sets policy direction and implements the laws and policies using powers granted by the legislature. And you'll see there we have number 10 Downing Street, and we also have our executive. Now, that's a slightly older photograph because, and there's, my goodness, there's our chair sitting at the right-hand side of it. But that's our executive, which is the capital E executive, which is also the small e executive branch of government here. Now, here's a photo of some bird watchers, which I culled from a Washington Post article called "More Americans Are Taking Up Bird Watching." But I put it in here to illustrate the idea that it's not just departments, that agencies and arm's length bodies are part of the executive branch of the state. And then there's an outer layer of independent bodies, which often have an oversight role. But different words for them. Agency is part of a department. A trading fund may be within a department. A non-departmental public body is at arm's length, an arm's length body. It's separate from the department established by the statute or prerogative for a particular purpose. And then there are public corporations established as a company, subject to company law, but established again for a special purpose within the public sector. And your go-to on this is Managing Public Money, Chapter 7, which is an absolute treasure trove if you are an arm's length body or if you're dealing with an arm's length body. And finally, they are all part of or related to the executive. Finally, we have the judiciary, who are independent of the executive and the legislature, and they adjudicate in disputes, including those between government and citizens. And I'm sure all of you here have been through the pain of judicial review. So when we say that ultimately most of our powers come from statutes, Act of Parliament, Act of the Northern Ireland Assembly is also a statute, because Parliament has given the Assembly all of its power. It shares the full extent of its power with the Assembly within the transferred area, in those things which aren't accepted or reserved in the schedules to the Northern Ireland Act. But many of our departments have power to make secondary legislation. So that primary legislation gives the delegated body power to legislate in order perhaps to further. Parliament has delegated its legislative power to the department. Powers may also be implied in statute. Then there are the prerogative powers, which are those special powers that the Crown has. They come from the Queen, but Section 23 of the Northern Ireland Act says that they are exercised by Northern Ireland ministers and departments on her behalf in relation to transferred matters. And that may be, for example, setting up a non-statutory body for a particular purpose and being able to appoint people to it. The next one is the common law powers of the Crown. So the Queen, like anyone else, is a normal legal person who could, if she wished, go into a shop and buy a packet of Polo Mints. We know famously the Queen doesn't carry money, but say she had an equerry with her who would have some money, who could buy the Polo Mints. But all of those powers, the powers to make contracts, the powers to employ people, if you are doing a big program of work that is going to require legislation, you can do the preparatory work using the common law powers of the Crown. So say, for example, you needed to set up an app to deliver online to deliver an online service, and ultimately there's going to be a statute, but you need people to develop that app. Because that is ancillary to your powers, you can use the common law powers of the Crown to employ people and to enter into a contract to develop that app. You may also be subject to general statutory powers, for example, the Interpretation Act, or if you're a company, if you work for an NDPB, which is a company, you'll be subject to company law, and you'll have to do things like submit your accounts to Companies House every year. So let's look at the powers. We're going to look at the powers of departments. We're then going to look at the powers of NDPBs. And finally, we're going to look at the general constraints on your powers. Everybody happy? Great. Yes, Anne's got her thumb up. That's great. So who can use a legal power in a government department? I know there's some of you here from government departments. So I just want to look at the difference between the way that departments here are set up and the way departments in UK Gov are set up. It's a bit techy, but if you are a bit techy about constitutional law, you'll find it interesting. And if you're not, do try to just see what is important about this. So in UK government departments, the Secretary of State exercises the whole power of the Crown, as all Secretaries of State have done right back to Sir Richard Rich in the time of Henry VIII. If any of you read Wolf Hall by Hilary Mantel, you'll know Sir Richard Rich as a character in that book. He was the Secretary of State. He had the King's seal, and he could take any decision. The King delegated the whole of his authority to him. He could take any decision that the King could take. So all Secretaries of State, that's the power they still exercise, and that's why they exercise it. They are assisted by Ministers of State and civil servants, and they are all exercising the power of the Crown as well as their statutory powers. Agencies and arm's length bodies report to the department. Statutes give powers to the Secretary of State. And the reason that they don't say the Secretary of State for Business or the Foreign Secretary, mostly, is because the law sees all of the Secretaries of State as one Secretary of State. They are all, if you like, avatars of that constitutional notion, the Secretary of State. But the Secretaries of State are accountable for their own and their ALB's work to Parliament. So you can see the doctrine that we call the unity of the Crown in, and the reason that that is important is because it is different in Northern Ireland, and sometimes our English counterparts don't realise. In Northern Ireland, the executive power, including the prerogative, is exercised by, quote, Northern Ireland departments and ministers. Statutes tend not to give power to the Secretary of State or the minister. They give power to departments. Departmental power is exercised subject to the direction and control of the minister. And we all remember the knots that we tied ourselves into when we had no ministers, trying to find a way to keep the lights on and keep the benefits being paid. Because if subject to meant under, no ministers, no direction and control, nobody ain't going to get to do nothing. You've got the thing that the Americans talk about when they're having their budget debates, a government shutdown. But we were fortunate because our legal advice allowed us to say that subject to didn't mean that. Subject to meant, I might, for example, say, here, Anne, why don't we get a cup of coffee after this? Subject to me having to check my email. So there's an if, there's an air of kind of, well, might happen, might not happen about it. The courts ultimately didn't like that argument, but they did admit that there was a small space for everyday decisions where we didn't need ministerial control. And then, of course, we had the FFA, the Northern Ireland Executive Formation and Exercise of Functions Act, which gave us a wider scope and allowed us to take more decisions until we got our ministers back. But this idea that power is given to departments, each of the departments are a separate legal entity. They each have legal personality. Departmental decisions can be taken by a senior officer or a minister. Agencies and ALBs report to the sponsor department, but the department is accountable through the minister to the Northern Ireland Assembly. So legal powers and departments. Now, you may hear people talking about the Carltona Doctrine. I don't want to go into it in detail, but it essentially says that in the English departments, because Secretaries of State are kind of emanations of the power of the Crown, and the department is the Secretary of State's alter ego, it's all kind of very metaphysical, and you don't have to specifically delegate powers. You can say that they say public business. So Carltona was a wartime decision. The Commissioner of Works was the Commissioners of Works were a body whose power was exercised by a Minister of State. And during the war, they requisitioned property. It was part of the same powers that allowed you to intern foreign nationals. It was very, very, very wartimey powers. So a senior civil servant requisitioned somebody's factory, and Mr. Carltona was really quite unhappy about that and said, hold on, the minister should have done this, but it was just some poxy civil servant. And the court, Lord Green, who was the master of the rolls, said, public business could not be carried on if that were not the case, if civil servants didn't do the work of ministers. Constitutionally, the decision of such an official is, of course, the decision of the minister. You know, the whole kind of metaphysical power of the Crown comes down, they're all the power of the Crown. The decision of such an official is the decision of the minister. In other words, this isn't delegation, but the minister is responsible. It is he who must answer to Parliament, and he has to select an official who is of sufficiently senior standing to take the decision. Okay, so this is the absolute foundation of how government works in UK Gov. Important thing to remember about it, it doesn't apply to Northern Ireland departments. Now, effectively, our system looks quite similar. But because statutory power is given to the departments, they each have their own legal personality. So today, I have slipped away from an exciting judicial review to talk to you, which is probably better. But in that judicial review, we have the Department for Communities on one side and the Executive Office on the other side. And so I'm representing one, and Hugh Hewitt, as the departmental solicitor, is representing the other. That couldn't happen in England because of the unity of the Crown. They're all part of the same thing, but our departments each have their own legal personality. That also matters if you, by the way, are sharing information between departments. You're going to have to think about data sharing agreements. But we then look at this question of who can exercise power in Northern Ireland departments. It's in the department's order. It can be the minister or a senior officer. And you'll see there also, I've given you section 23 of the Northern Ireland Act, which again says the executive power continues to be vested in Her Majesty, but it is exercisable by any minister or Northern Ireland department. Now, does that mean that we have got all the power in departments and we can do anything we want? Well, section 24 of the Northern Ireland Act sets out the limits on the power of what we can do. It can't be incompatible with the convention rights, so the human rights and the Human Rights Act. It can't be incompatible with retained EU law. It can't discriminate against someone on the ground of religious belief or political opinion. And it can't modify a list of protected enactments, which are, if you like, the constitutional statutes, the Human Rights Act, bits of the Northern Ireland Act, and also bits of the EU Withdrawal Act. I'd just like to go back and also mention, in relation to the Northern Ireland Protocol, there is a new limitation. We can't do anything which is contrary to Article 2.1 of the Northern Ireland Protocol, which is about no diminution of the rights in the Good Friday Agreement. Now, we have so far spent 3 afternoons in DSO sitting around a virtual table going, well, what the heck does that mean? Because the rights enumerated in the Good Friday Agreement are in Part 6. That's the part entitled Rights, Safeguards and Equality of Opportunity. And some of them look quite like human rights, but this is treaty drafting. It's also probably late night treaty drafting. It wasn't ever designed to be something that would limit the power of departments, and so it is really unclear what the limits of Article 2.1 are. Now, we think that mostly it's not going to be a problem, but some inventive and creative applicant for judicial review will no doubt bring it to a court, and we'll get some more clarity about what it means. We hope that it's narrower rather than wider, but my predecessor, Brian Doherty, was a very great lawyer. One of his phrases was, that's a toy we haven't taken out of the toy box yet. So we'll have to see when we take Article 2.1, well, when applicants take Article 2.1 out of the toy box, we'll have to see what limits it places on our power. So there's also the significant and controversial and cross-cutting matters. So you remember that in the Ministerial Code, it says that, so Section 28A of the Northern Ireland Act says, ministers must act in accordance with the provisions of the Ministerial Code. Para 2.4 of the Ministerial Code says, if a matter is cross-cutting or significant or controversial, and if it's significant or controversial, there's a second stage, and it's outside the programme for government, where we have one, then you have to bring it to the executive. Now, this just gives rise to endless fun and games, where some ministers are very keen to take the hard decisions to the executive so they don't get blamed for making them. Other ministers will want to power ahead with doing something that they want to do, which other ministers want to stop them doing, and will say, oh no, but hold on, you should have taken that to the executive. The reason that this is such a fertile ground for debate is that if you look down at the bottom of the screen there, without prejudice to the operation of Section 24, a minister or junior minister has no ministerial authority to take any decision in contravention of a provision of the ministerial code. In other words, this rubric, a provision of the ministerial code made under subsection 5, means the cross-cutting, significant or controversial provision. So if you don't bring it to the executive, and you should have brought it to the executive, you then you have to you don't have power to take the decision. So what I'd like to say specifically about that as well is that the courts have been less than helpful in deciding what is cross-cutting, significant or controversial. The Functions of Government Act just last year said cross-cutting doesn't just mean that another department is a wee bit interested in it. It has to actually impact on their functions. So that has become a bit of a higher bar than it was. But the courts have also said in a case called Central Craigavon that anything that the executive thinks is significant or controversial is significant or controversial. So it's a matter of judgment, it's a matter of fact. But that makes it a little uncertain because, of course, it is a political matter. So thinking about your departmental business area, we've looked at the general scope of departmental power, but you are also given specific powers. For example, the Department for Education has a duty to make provision for the education of people in Northern Ireland. And then it has a number of duties which fall from that, a number of powers which fall from that. For example, the power to spend money on doing that. You can't do something if you don't have a power to do it. There are a small number of general powers. We've looked a little bit at that, at things like the prerogative, the common law powers of the Crown. But by and large, you can't act outside your statutory powers. That includes, and when you move into a new business area, it's useful to ask around, to look around, to find out where your powers are. Do you have regulation making powers? Do you have powers to give out money? The Department for the Economy at the moment, for example, their grant schemes for COVID, they had to operate through Invest Northern Ireland because they themselves don't have a grant giving power. Are there any quasi-judicial decisions that you or your minister have a power to make? We're going to be looking at one in a little minute, which is about firearms appeals, which is a function of the Minister for Justice, which is, you know, one of those little kind of surprise powers that you didn't know was there. When you think about powers, you need to think about whether a sufficiently senior officer is taking the decision, because that's something that may come up in judicial review. Because, you know, it's a senior officer of the department. In Article 4 of the department's order is the person who can take the decision. So are you a senior officer, or who is the senior officer who is taking the decision? And that doesn't mean it always has to be the permanent secretary, but it will vary according to how serious the decision is. You also need to ask in Northern Ireland whether any of your powers belong to the minister. Because, you know, the Carltona Doctrine says, well, if it's power of the minister, metaphysics of the power of the Crown going down through the department to the civil servants, you don't need to delegate. Because most powers are given to departments in Northern Ireland, where a power is given to the minister, the courts will always say the drafters knew what they were doing. They clearly intended that power to be exercised by the minister. So we want the minister to have considered it, okay? Now, you want to ask, are any of our powers in other documents? Do we exercise powers jointly with anyone? Have we got any sets of guidance, or for example, the Department of Agriculture, or the planning division in DFI. The planners have a power to issue planning policy statements, and those planning policy statements have the force of law, and they and other departments will have to operate within the boundaries of them. So watch out. I think a piece of homework that I would give anybody who is new into a business area who was at this session is go and find out the answer to all of these questions and get a file that has or put tabs on your home page so that you can get your powers. You know your powers, you know what you can do. Think about acting jointly with other bodies. Whose power are you using? And who, if it's their power, do you have to be consulted? Do they have to take the decision? How do you put together the route to the right person making the decision under the statutory power? Do you ever use prerogative or common law powers of the Crown? Because, for example, in Department of Justice, they exercise the royal prerogative of mercy whenever someone isn't going to be acquitted because technically they committed the offence, but there is some reason to exercise the royal prerogative of mercy and to treat their conviction as if it has never been. And those, I must say, are always fascinating cases. So we are going to look at two examples now of departmental power. And the answers to the questions are not difficult, but it just requires you to look at the statutory language. Now, some of you are quite senior people and you'll be well used to looking at statutory language and you will romp through these. If you're a little bit newer to it, statutes can be quite confusing. They can throw you, but you just have to keep your head and work your way through them, because a statute isn't so much like prose as like an algorithm. Each sentence is there for a reason and you have to tick each one off on your way to your decision. So due to the limitations of our technology, you're not going to be able to look at these screens when you go into your small groups. So what I'd like you to do is, if you have a second screen, you'll have got an email with these screens on it, with these slides on it, and just bring it up on your second screen for your small group. If you don't have a second screen, I would suggest that you take a photograph of the next 4 slides, this one and the following 3, to use in your small group. So here we have appeals under the firearms order. A person aggrieved can appeal. The relevant authority may make such order as it thinks fit, having regard to the circumstances. Here are the decisions in relation to a firearms license to which it applies. And in this article, here's a definition of who the relevant authority is. So nice, straightforward, but slightly wordy provision. Everybody got a photograph of it? Yeah, everybody's captured it. 5, 4, 3, 2, 1. Next slide. So here are 2 firearms appeals, and you're being asked to advise the Northern Ireland Minister for Justice. You can tell that we have got a subscription to BritBox from all of the names that you'll see in these worked examples. But Tom Good is appealing refusal of his firearms certificate. He has received 2 warnings from police for firing a shotgun in a built-up area. He says he was destroying magpies' nests. He says he'll undertake not to use a shotgun again, but the police say he already gave that undertaking after the first warning, and a letter from his GP says he has early stage dementia. Now, next one is in relation to Margot Ledbetter, who appeals refusal of her firearms certificate. She's secretary of her local clay pigeon club. Their gun cabinet was emptied when the club was burgled. MI5 intelligence says it was the work of a paramilitary organisation. Wow, who sold the guns on to international terrorists. Police believe the cabinet was left unlocked on purpose, and Margot is one of only 2 key holders. So 2 firearms appeals to apply the statute to. Going to let you take a photograph of this slide. 5, 4, 3, 2, 1.
No,
Everybody okay?
no.
No? Anybody want to have a little minute longer? So you have these by email, but if you only have one screen, you'll want to just use your phone to take a snap of them. Going once, going twice. You got just two more of these, okay? So here are some education grant making powers for higher education. Powers of the Department for the Economy. You'll see on one side, we have the general duty to promote education. Again, take a photograph of this. On the other side, we have a power to make grants to governing bodies of higher institutions of education for 2 purposes, provision of education and provision of facilities and activities. And then if we go down to C, I left out B because it wasn't relevant and it would have made it even more ridiculously small. C is other people to whom you can give money for services, for purposes of or in connection with the provision of education and the undertaking of research by higher education institutions in Northern Ireland. So take a wee opportunity just to get a shot of that. And 5, 4, 3, 2, 1. We move on to a dilemma. Now I'm going to ask you to choose either the firearms appeals or the minister's dilemma here in relation to educational funding. So Jill Hacker is an interim minister for the economy, and she has been asked to provide funding for 3 things. A new submolecular mass spectrometer. I made that up. I don't even know if that's a thing, but it is very expensive. And a sterile lab in which to locate it for University of Ulster Biosciences. A state-of-the-art laptop computer as the prize in a COVID vaccine raffle for students at Queen's. And an English-speaking student community local council liaison officer for 1 year at the Universidad de Alcalá de Henares, which is in Madrid, a popular location for Northern Ireland Erasmus students where there has been some friction between the locals and hard-drinking Northern Ireland students. So as you're taking a photograph of that example, if that's the one you'd like to look at, I'll tell you that that last example comes from, it's similar to real life. I used to be the Erasmus rep when I was an academic. I was the Erasmus rep for the law school at Queen's, and we got a very upset phone call from my opposite number at Alcalá de Henares. And she said, Claire, I think your students this year have a problem. And I would like you to contact their parents because we have a concern about their welfare. And I said, okay, I'm very sorry to hear that. What is the problem? I said, well, they all go out on a Thursday night. And when they come home, they must drink about like 6 glasses of wine or something. Because when they come home, they're singing and they're laughing and they're really rowdy. And then they go out on Friday night and do it again. And I was like, no, don't worry. That's just that's a cultural matter. That's just normal for our students. So we called the students and asked them could they tone it down a bit because they were upsetting their tutor. But no, that was just perfectly normal. So different cultures around alcohol. But everybody got those. So I'm going to ask you in your groups to decide if you want to look at the firearms appeals or at the funding decision, really depending on what you find most interesting or what's most like your your example, your own work. So, Anne, if you'd like to press the button, please, and put us into our small groups for another 6 minutes this time. Okay, thank you. Can you guys see my screen?
Yeah.
Yeah. So why can I not see it? Right. Right. Okay, something weird has happened with my screen, but I know that we had a question in relation to, don't you know what, I'm going to stop sharing, guys, if you don't mind, and just try to share my screen again. Screen 2, share, and participants can now see my screen. Great. So we had a question on the chat there, which was, are we, who is a senior officer? And the answer, hold on, let me just try to do, let me just try to, I'm fascinated by why my, that's better, that's better, good. Who is a senior officer? It's a really, really good question. And by and large, I would say if you're a member of the senior civil service, you're a senior officer. But there will be decisions which are more serious than that, where you will want the DepSec or the PermSec to have had a look at it. But by that, I don't mean that the grade 5 has to spend hours slaving over looking at all the documentation and writing up the submission and making the decision. They can have someone assist them in the preparatory tasks, but the one who looks at, if you like, the final submission and takes the decision needs to be a senior officer of the department when you're actually exercising a statutory power. So let's look at our examples. Now we look at the limitations of the technology again, because it's not clear to me that I can see the chat bar. On this, can I see the chat bar? No, I can't. So we're going to have to do a shout out. Who dealt with the firearms appeals? Now you're advising the Northern Ireland Minister for Justice. Who was dealing with the firearms appeals? Anybody want to start us off? Would you have allowed Tom Good's appeal?
I can try and answer that, Claire.
Yeah, Peter.
We dealt with that, and we were looking at two-stage process. Firstly, do they have an appeal, and they obviously does have an appeal, or a right to appeal, but then under section 2,
yeah,
it's the relevant authority may make such an order they see fit, having regard to the circumstances. So in both instances, the circumstances would suggest that the minister could refuse the appeal, given in the first instance that he was using it in a built-up area. He'd given undertakings before, he had warnings, and there's the medical question as well. So
exactly.
That's in relation to Tom.
And very good. Yeah, in relation to Margot.
In relation to Margot, then
whose decision? Who? First question with Margot is, who's the relevant authority?
We didn't address that. We just thought, okay, she has an appeal because it's here, but the relevant authority. Are you referring maybe to Article 5 of that, where it's referring to on the grounds of national interest in national security?
That's right. It's a so the question with this is, and again, it's a judgment question. Is this a national security matter because MI5's involved, or is this, if you like, ordinary decent terrorism? It's local. The minister could deal with it. It's an open question. I might try to kick it across the Secretary of State, but But if you were dealing with it, what would you do? Would you give Margot her firearms license back?
We wouldn't have, but
Wise move.
in relation to Margot, she would obviously be saying, okay, there would be, you would assume, a police investigation into this matter. So if the other key holder was found, let's hypothetical situation, say she was found to be the one, he or she was found to be the one given access, then Margot would have a stronger case in her appeal, obviously.
Exactly. So basically, you're absolutely right. You're going to leave this appeal until after the criminal investigation. But the other question there, and it's just a reminder to kind of go through your statutory power, is would this be one for the Secretary of State, or would it be one for the Minister for Justice? But well done. Two very sound decisions there. Now, did anybody deal with Jill Hacker and the things that she is going to be spending on students? Anybody deal with that one? Nice funding decisions there. Or did everybody do the firearms appeals? Good. Well, listen, shall I tell you the answer to this one? Now, obviously the submolecular mass spectrometer, it's a 1A power. So it's provided, or hold on, let me go back a slide. So it's definitely promoting the education of the people of Northern Ireland. And then in relation to Power A, governing body of any higher education institution, 1, the provision of education or the undertaking of research by the institution. So it's clearly for research, it's clearly within the power. That was the easy one. And the other two really are their judgment calls. A state-of-the-art laptop computer, they want to encourage vaccine uptake. Now, that's not directly to do with the provision of education, but is it an A2? The provision of facilities or activities by that institution which the governing body considers as necessary or desirable to provide or to carry on for the purposes of education or research. So is making sure that the students are vaccinated primarily for the purposes of education, or is it for some other purpose like public health, which is very worthwhile, but it's not within the power. And that's a finely balanced question. You could argue it either way. I might suggest that they get their own flipping laptop because I think it is a wee bit remote, but it's certainly arguable either way. Now, then we have,
Louise has her hand raised.
Yeah, Louise.
Well, I think Clara's answered my question. Surely that sort of a decision doesn't have to go to the minister.
So it wouldn't have to go to the minister, but I liked the name Jill Hacker, so I put it to the minister. But no, that's absolutely right, and it would be departmental decisions. But it's the sort of thing that you imagine a minister might be interested in.
Yes, so they want to announce it. They want to make sure they've got cover for it.
They want they want a photo of them with the laptop and a student, I'd imagine. But no, you're absolutely right, and it's a very good point. And then we've got our local council liaison officer in Madrid. And this is actually, I was given some advice last year on Erasmus and successors to Erasmus, and got interested in this question of any body or person in respective expenditure incurred for the purposes of or in connection with the provision of education by higher education institutions in Northern Ireland, because actually you can make payments to universities abroad under this provision because it's in connection with the education of students by the Northern Ireland institutions. But the education institutions in Northern Ireland. But again, my question in relation to this one is, what is the dominant purpose? Now here you can be a little bit more remote because it's for the purpose of or in connection with education, the provision of education. And again, you can make an argument, but I'm not sure that I think it is a little bit remote. If it had been an overseas student liaison officer in the university or an alcohol counsellor in the university for the Northern Ireland students, I could see it as a little bit more closely connected. But this is someone in the council who is probably more about smoothing the ruffled feathers of the people who've had their night's sleep broken by the students. What did anybody else think of that one? Louise?
Yeah, I think it's one of those, not really terribly legally tied up.
Yeah.
It's very much, as you say, diplomacy, keeping relations going, and so on. So very hard to call, really.
It's so
maybe not 1 year.
mm-hmm.
Get somebody out there, get good communications going, get stakeholder engagement, all of that. But as long as it doesn't turn into, a Nolan show of somebody on a jolly to Spain for a year.
Yeah,
at
although
the taxpayer's expense.
you and I might both might both throw our hats in the ring for it. No, that's exactly it. And really, the purpose of this, again, it's a judgment call, which will just get a bit of conversation going in your group. But it's about tying the debate and the judgment that you're making to the exact phrasing of the power that you're using, So shall we move on? Does anybody have any other questions? Any thoughts? Any going once, going twice? Shall we look at non-departmental public bodies? So where do you find the legal powers of non-departmental public bodies? And again, if you're working for an NDPB, have a look at them, take them out, know them. They'll be in the parent statute. If you're a limited company, they'll be in the general law. There's also an important set of provisions in the Interpretation Act 1954, which are the general powers of NDPBs. But be alert for the limitations on your powers. Your power to act is only for the body's purposes, so know what your purposes are. Your power to spend money, and again, the reason we looked at that general power for the general duty in relation to education and the power to spend money in support of the general duty is to see the way in which spending powers are limited. And you will have power to give grants to particular classes of person if you're a grant giving body for particular purposes. And it's a case of always tying in what you are doing to your purposes and making sure that you stay within your powers. So I took an example, which is a body that I know reasonably well, the Human Rights Commission. Its powers are set out in the Northern Ireland Act 1998, section 68 to 71. And the nuts and bolts are set out in Schedule 7. Now, some of these are the same as quite a lot of other bodies. Some of them are quite different. If you look at the statute, you'll see that it is set up. There shall be a body called the Northern Ireland Human Rights Commission. It says how many commissioners there should be. It says there should be a chief commissioner. Now, one thing that you often find missing is deputizing arrangements. What happens if the chief commissioner is off, or the chief commissioner is incapacitated? Can decisions be taken if they, and it'll be set up in different ways, that the body can take decisions if it has a quorum. Doesn't matter if the chief commissioner is there or not. But if the chief commissioner themselves has specific functions, you'll also need a deputizing power. Because the Human Rights Commission is a constitutionally type body, there's disqualification, there's people who can't be in it. It sets out a big long list of functions. Some of those are expressed as duties. The first one is that the Commission shall bring forward provisions for a Bill of Rights. Now, that didn't go entirely to plan, but they did do it. It also has powers. it shall, we'll look at one in a wee minute, promote education on human rights. And to do that, it may commission research and reviews and reports. It has investigative powers, and it's quite a good model if you're looking at a body, or if you're thinking about bodies that have investigative powers, because they need powers of compulsion. In particular, they need powers to call for papers and powers to make people appear before them, because otherwise they're just asking nicely and people can say, no, we're not going to. Those were given to the Commission later. It didn't originally have those powers. It also has a power to assist individuals, and that it's a power to bring cases in support of individuals who have got human rights concerns. But again, those are very circumscribed as to the sorts of people, the sorts of circumstances in which it can engage. So those are the high level, that's the what of what it does. And then if you look at Schedule 7, it sets out things that you will see for almost every NDPB: commissioner's tenure, their salary, the power to employ staff, the power to make staff's pension contributions, the duty to provide an annual report, the duty on the government to provide it with sums of money annually, bits about procedure, about quorum, about how its board should proceed, and a little bit more about disqualification is in there as well. So it's really just to say this is quite a good model. If you're looking at the powers of your NDPB, it may follow this model where there's a parent statute which sets it up. There will be some provisions in the schedule about the nuts and bolts, and then that will also be supported. Let's just look before I talk about the next level of documentation. Here's one of their functions. It's 69.6. The Commission shall promote understanding and awareness of the importance of human rights. See shall, that mandatory language, it's a duty. And for this purpose, it may undertake. And so here's discretionary language. It's a power to undertake, commission, or provide financial or other assistance for research and educational activities. Now, we're going to be doing an exercise on this specific power. So I'm going to give you a few minutes, sorry, not a few minutes, I'm going to give you a few seconds to either pull it up in your email or take a photograph of it. So section 69.6 of the Northern Ireland Act. We're going to take a photograph of it in 5, 4, 3, 2, 1. And then we're going to look at Schedule 7.4, focus on establishment and staffing. The Commission may employ staff subject to the approval of the Secretary of State as to numbers and to remuneration and other terms and conditions of employment. And again, you'll often not see the subject to approval bit. That's different, but it's otherwise it's a reasonably standard. They need a specific power to employ staff. They need, in this case, Secretary of State approval as to the numbers, the remuneration, and the terms and condition. Don't worry about that. I'm just showing it to you for interest's sake. So every NDPB can get the benefit of the Interpretation Act 1954, section 19 of which is dead handy. Keep it in your back pocket. Even if it doesn't say in the statute that it has these powers, all NDPBs will have this power, okay? When an act passed establishes or provides for the establishment of a body corporate, and I will be sharing these slides with you after the course, so I hope that that'll be helpful. These words shall operate. So the body will have the power to sue. It'll have the power to enter into contracts. It'll have the right to acquire and hold land. It'll have the right to regulate its own procedure and business, the right to employ staff. And you'll see that therefore the Northern Ireland Act didn't have to say the right to, the Northern Ireland Act is subject to a different Interpretation Act, but So just ignore what I said. But anyway, the right to employ staff, to make the body liable to be sued in its corporate name, to vest in a majority of the members of that body the power, that's the members of the board, the power subject to any quorum to take decisions, and to exempt from personal liability such members as do not contravene the provision of the act under which the body is established. So those of you who are members of boards, of bodies, of public bodies, will find 19(1)(e) quite comforting. You're not personally liable for the debts, etc., as long as you don't contravene the provisions of the Establishing Act. So Section 19, really important. There has been a trend to try to stretch Section 19 to include, for example, a right to delegate to staff. But that recently got chinned in a case called McKee and the Charity Commission, which some of you may be familiar with, and which was actually one of the reasons for bringing this this course together. I'd be happy to talk about McKee at the end if you want, but I know there's some folks in the Charity Commission here, and really the rules that I would draw from it are much more general. But behind the statute and behind the Interpretation Act, there will be a second layer document, which is called the Management Statement and Financial Memorandum, or in more modern language, a partnership agreement, maybe either or. You will also, if you're getting a file of all your powers of your establishing statute, put the MSFM or the partnership agreement in with it, because that contains the legal basis of the relationship. So it will tell you, it should tell you where your powers come from. It tells you your objectives and your key outcomes. It talks about governance in terms of engagement. It'll talk about accountabilities. It'll talk about strategic decision-making, about planning, about controls, stewardship reporting, risk management, staffing issues, and professional input means, so this all comes from Managing Public Money, which you all know is a brilliant document that everyone should read, although frankly quite tedious. I recommend, if you decide you're going to sit down and read Managing Public Money, a packet of biscuits and a flask of tea are absolutely essential to keep you going. But chapter 7 is where you will get, sorry, I didn't mean to knock that on, all of this stuff. When they talk about professional input, they talk about the employment of scientists. I've never had to employ scientists, but if you do, it should be in your MSFM as to the terms in which you can do that. Performance management, lessons learning, financial management, monitoring, reporting, liaison, tracking, and audit, all of those things should be in your MSFM. Really, really vital document for the government of an NDPB. So, if you're outside central departments, who can use your body's legal powers? So, anybody who's into Latin and wants to throw Latin tags around, the Latin tag is delegatus non potest delegare. The person to whom power is delegated cannot sub-delegate it. In more modern language, this is the rule against sub-delegation. The rule is everywhere except in UK government departments. So if Parliament gives powers to a Northern Ireland minister, this rule applies, because remember, the normal thing in Northern Ireland is that powers are given to departments. The power must be exercised by the person to whom it is given. Unlawful subdelegation renders a decision unlawful, void, and of no effect. So I always feel I have the two door handles there. I always kind of get flashbacks to Sunday school and to people talking about the broad. Will you take the broad road that leads to destruction, or will you take the narrow road that leads to good decision making and a happy board. Okay, so what do we mean by delegation? A public body acts by its board, so the board has to take the decision. It can delegate ancillary activities to staff, contractors, or partners. Now, the example I've given there is applying a signature stamp to a document, because there's a planning case in England where, excuse me, the local council chief executive had to make planning decisions. And he made the planning decisions, but he had a little rubber stamp made with a facsimile of his signature on it. And those planning decisions which were passed, his secretary applied the rubber stamp. Now, because he had actually considered the decisions, that was okay. This was only an ancillary activity. The more usual sort of ancillary activity would be getting in information, writing submissions, setting up a system for the payment of grants, for example. But the core of the function, the core of the decision making, has to be taken by the body to whom the power was given. You may have a statutory power to delegate, and if you do, the whole function can be delegated. So, for example, a Northern Ireland department in Northern Ireland Act Section 28 can enter into an agency agreement with a UK department or a public body to carry out a function. And that was what we were looking at in relation to the Turing scheme, the successor to Erasmus, but I don't know how that has subsequently worked out. But unless delegation is granted by express power or necessary implication, a public body can only enter into agency arrangements for ancillary activities. So you could, for example, if you were the Department for the Economy and you wanted a UK-wide body to give grants to students who were going abroad, because you have the Section 28 power, you could enter into an agency agreement with the Department for Education in London, or with the, what is it called, the UK Research and the UK Higher Research and Education Council, which is a public body. Statute says a department or a public body. You could enter into an agency agreement for them to do that for you. But in England, departments can enter into an agency agreement with private bodies. We don't have that power. So if they then said, oh, we want Centrica to administer that scheme and to give those grants, we wouldn't be able to join them in that. They couldn't sub-delegate to the private body on our behalf. And when we were looking at that, we were saying, well, do you know what? If they drew up a list of proposals, that they did all the administration and got a list of the students to whom they thought grants should be payable, they could send those back to the department, and the permanent secretary could look at them and exercise some kind of meaningful control, and maybe that would be enough. But as long as we don't delegate our whole function, just the administrative support. Now, this phrase necessary implication, delegation by necessary implication. We're going to look at that in a wee minute, but before we do, I'd like to look just at this core of a function idea. So there are two cases which come from the 1920s, where local authorities in London had the power to certify films for public viewing. And one of them set a policy that it would only show films that had been given a certificate by the British Board of Film Censors. Sounds like a perfectly sensible decision, but it had unlawfully delegated the whole of the function. So it had unlawfully delegated its decision making. Now, few years later, second local authority, cunning, clever local authority, was exercising the same power. And it set a general policy that it would show films which had got British Board of Film Censors certification, but it retained a power to override the general policy. It had a power of review. So the whole power hadn't been delegated, and its general policy was lawful. For me, that is kind of how close to the wind you can sail, but just that idea of the whole of a function is really important. Now, this question of necessary implication, and this came out of the McKee case, the Charity Commission case. You can, in that case, the issue was, could you delegate decision-making to staff? There are two different kinds of body. One is where you've got a big body where power is given to the head of the organisation, just because they're the head of the organisation. The organisation is hierarchical. If the power in question isn't final or decisive, and a heavy pressure of business makes delegation inevitable, then delegation will be implied. And in a sense, that's like an individual version of Carltona. The business of government couldn't run if they weren't able to delegate these decisions. A good example there is local government. And you'll see that the cases on local government in the modern era are quite relaxed, because now the Local Government Acts set out a whole hierarchy and schedule of delegation, and you're operating inside that, and the courts will be quite relaxed about it. Another body is the police, where they're quite relaxed about decision making, because it's clear that the business of the police couldn't run if the chief constable had to make every single decision. But if there are a number of things that will make a court say no delegation, you couldn't have expected this decision, you wouldn't expect this decision to be delegated. One would be if the power is given because of the office holder's expected experience or qualification. So, for example, the chief pathologist of Northern Ireland has to certify certain autopsies. He's not just doing that because he's the head of the pathology service. It's because he is a doctor who's really, really good at slicing cadavers. So, and drawing conclusions from it. It's because of his professional qualifications and his expected expertise that they want him to be the person who certifies those complex autopsies. Another one would be if the power in question is final or decisive. I would probably add to that, or significant, where you really would want the top of the office to have looked at it. Another would be if the power in question is quasi-judicial. In other words, it's affecting the rights of individuals. And that was one of the issues in McKee. Another of the issues in McKee was that there weren't a squillion of these decisions every year. It would have been possible for the Charity Commission Board to meet and to take those decisions. I mean, obviously based on reports by the staff, but the workload is not so heavy as to make delegation inevitable. And that's a really important, when you're in that territory, it would be important to get legal advice, but it is stuff that you can look at yourself and just identify where a particular decision sits. It'll come down to interpretation of the individual statute. And I think that one of the things that we have done today is to look a little bit just at the necessity to read a statute closely, and also to read the statute as a whole, because there may be another bit of the statute that ties into the decision you need to make. Right. We have one more fictional example if you want to take 5 minutes. So,
if you don't mind me stepping in at this stage, we're a
Yep.
bit over time.
Are we over time?
We are a bit
Let's look
over
at that
time.
in our own time then.
Yeah, I think to do that.
And I can't see. I'll tell you another problem with Zoom is that I can't see a clock.
Okay, yeah.
But
So we're 10 minutes over.
is this okay? Do people want to take 2 minutes to look at the rest of the slides, or shall we call a halt?
I think good questions there on NDPB powers, if we could have a quick look at that. And if anyone has any very specific questions they'd like Claire to address before we do wrap up, if you want to pop them on chat now or use the raise your hand function, we'll try to come to you. But any questions, if you want to put them on chat now, as Claire runs through the questions about the powers for NDPBs.
Thank you very much for that, Anne. Some good questions about the powers of your NDPB. Again, it's about what statute contains your powers. What about grants or loans? What about appointments? What powers do we have to make quasi-judicial decisions? Who can exercise the powers? Which of them can be delegated? And do we have a schedule of delegation so that we've actually thought about that issue? And also, are we a corporation? Does company law apply to us? Now, the final section of this talk was an experimental one. I wanted to go into the general limitations on your decision making, and which takes you into judicial review. For those of you who are in departments, CAL runs a course on judicial review, which will dovetail really nicely with this material and help you to think about the general powers of decision making. When you get the slides, there is the 10 commandments of good decision making are taken from Judge Over Your Shoulder, and they are a really good thing to think about alongside your use of powers. But today has been all about the powers that you have, how you can use them well, and I hope that that has been helpful and that it will help your organisation to take transparent, well-reasoned decisions which will help your stakeholders and your customers to feel that they're being treated with fairness and with dignity. I'm going to hand back on that to Anne and to see if there's any more questions, and then to wrap up.
Thank you, Claire. That's been a really excellent session, and you'll be glad to hear no difficult questions on the chat, and lots of thanks for your input on this session. You all now know where Claire is. You'll be getting the handouts shortly, and I think I'll speak for you, Claire, when I say you'd be happy to pick up any particular issues or concerns that people may have in relation to their own bodies. So thank you, Claire, for your time, and would really appreciate if our attendees could fill in the survey, which we'll circulate shortly, to help us shape this session for the future. And with that,
Definitely.
I'm going to hand back to our chair, David, for a final wrap up. Thanks.
Thank you. Big thanks to you, Claire. That was excellent. Despite my many years of service, I actually learned a few things there. And can you make sure I get a copy of the slides as well? We have run a little over time, but I think that just shows what a big area this is. And certainly, I think this is something that we would probably want to run again. And I can imagine a lot of people will get a lot out of it. And certainly, if any of you bump into the ghost of Tony Benn, you'll certainly be in a much better position to answer the question, what power do you have and where did you get it? Or at least if you can't answer it, you'll now know where to go to look for the answers to those questions. So again, I'll not delay. Huge thanks to you, Claire, for that. That was really stimulating, really good, and I'm sure it has given us all lots of food for thought.